Okay, this is Dart Container of Michigan, LLC, and Atlas USA Holdings, LLC versus Mills et al., docket number 20-333CB. This is the time set for hearing on a variety of matters. We've got the plaintiff's motion for partial summary disposition, the Mills defendant's cross motion, and the plaintiff's motion in limine. And then I took under advisement a motion to compel by the Mills defendants from several weeks ago. And we will start first by getting appearances on the record, and then we'll start with plaintiff and then go to go to Mills defendants and then Hughes defendants.
Thank you, Your Honor. If the court please, Scott Mandel presenting the plaintiffs.
Jim Jensen representing the plaintiffs.
Brandon Shoemaker representing the plaintiffs.
Joseph Falcone representing Mr. Mills and Mills Real Estate Company.
Jennifer Gross representing the Hughes defendants, Your Honor.
Okay, and then before you start your argument, let me just review that I received, and this is just with regard to the motions for summary disposition. I've got the plaintiff's motion for partial summary disposition. I've got the Mills defendant's response to the plaintiff's motion and the Mills defendant's cross motion for partial summary disposition. I've got the Hughes defendant's response to the plaintiff's motion, the plaintiff's reply to the Hughes defendant's response, the plaintiff's reply to the Mills defendant's response, and the plaintiff's response to the Mills defendant's motion, and the Mills defendant's reply to the plaintiff's response. And I have read all of those, and I would just note that the Hughes defendant's response to the plaintiff's motion, I believe, was filed back on February 3rd. I got my judge's copy today because I guess there was none sent previously. I had previously read it by going through our computer system to read it once I was alerted to it by getting the plaintiff's reply. So I did have adequate time to read it, but I just want to remind all counsel that we are not an e-filing court yet. We are accepting pleadings for filing by email, which is different than being an e-filing court. As long as we are still in the stage of just accepting filings by email, we do still require, and the court rules require, a judge's copy. So with that, we'll start out with you, I assume, are arguing this, Mr. Mandel.
I am, Your Honor. Thank you.
Go ahead.
Thank you, Your Honor. And Your Honor, if I may, as the court indicated, there are several matters up for decision today, or at least for review by the court. If I can try and address those in my argument, if that's okay with the court, so we don't have to go back and forth on that. Is that all right, Your Honor?
That's perfect.
Thank you. And Your Honor, I know the court has received a lot of briefing on this, and I also know how much attention the court gives to preparation, so I will try to tailor my remarks accordingly. Your Honor, we're asking on behalf of the plaintiffs for the court to grant this motion for partial summary disposition, which is limited to count 8, the anti-kickback statute. And the basis for our motion comes largely from the deposition testimony that we cited to the court and provided to the court. From that, we have confirmation from the parties. There's really no dispute here that this money was paid from the Hughes defendants to the Mills defendants. There is no dispute admitted by both that. Sorry, Your Honor, I'm getting some feedback. I'm not sure. Can the court hear me okay? But I'm hearing some feedback.
Yeah, you're a little choppy, but I'm not getting feedback. You're just a little bit choppy, but I can hear you. Thank
you. And if it's possible, Mr. Falcone, could you mute your mic? That might be part of what I'm hearing.
Okay.
And I don't know whether Mr. Hughes has the ability to do the same. That might be what I'm hearing. At least on my end, it's a little distracting, Your Honor. So anyway.
I've muted Mr. Hughes.
Thank you, Your Honor. Okay, and that does appear to be better. I appreciate it. Your Honor, what we have in the deposition testimony is the acknowledgement that money was paid, but that it was not reported to the principal and the employer, to Atlas or to the DART party here. So we believe that we have the elements necessary for the court to rule on the liability aspect, not the damage aspect, but the liability aspect under the anti-kickback statute. And we have some disparity here, at least by way of the briefing and the arguments made between the Hughes defendants and the Mills defendant. We have provided the deposition testimony of Mr. Hughes where he acknowledges, and we, again, that's quoted in the brief, that this was done for the intent to influence, to continue to get business from DART through Mr. Mills. That was, he was given that opportunity to testify to. He was concerned that if he did not continue to make those payments to Mr. Mills, it would negatively affect his future course of business. Mr. Hughes has signed an affidavit that calls into question his deposition testimony. And we cited to the court the Atkinson case that does not create a fact question. You cannot contradict deposition testimony by way of an affidavit. So we have Mr. Mills, on the other hand, saying by way of his affidavit that there was no agreement here. And at least for purposes of this motion and the statute, I want to, if I can, highlight that for purposes of Mr. Mills and the statute, it is not necessary that there is a quote unquote agreement. It can be an agreement or an understanding. So it doesn't have to actually be an agreement. And we've cited to the court the testimony of Mr. Mills, which was, on the one hand, he cannot offer any explanation of why Mr. Hughes was providing him with this money over this period of time. But he doesn't contradict, in the sense of at least his deposition, any reason. He said, I don't know. That's it. The best he does in his deposition testimony. So if there is a conflict with the affidavit and the deposition testimony, again, under Atkins, they cannot contradict that. If the court's of the view, well, this isn't quite a contradiction, at least on that score, what is a contradiction is that Mr. Mills, in his deposition, this is cited in the brief, actually did offer an explanation of what this money was. At first, he said it was a gift, that this money was given to him as a gift. He could not provide any explanation of why somebody would give him over $1 million over this course of money as a quote unquote gift, or why Mr. Hughes would pay him $250,000 for a single transaction as a quote unquote gift. No explanation at all on that. But in his deposition testimony, and this is on page 23, he does offer something. And what he says under oath there is that, when he went back and said this is no longer a gift, he was questioned by the Internal Revenue Service, and he retracted his position that this was a gift. He was asked, starting at line 12, page 23, and as far as you were concerned, was this payment a gift? Answer, no. Why did you receive a payment if it was not a gift? From 2016 on, I went with the IRS description of referral fees. Referral fees, is that correct? Yes. That's his deposition testimony. So what he said under oath is just what Mr. Hughes said, that this is a referral fee. And Mr. Hughes explained what a referral fee is. That is what we're talking about here. It's the quid pro quo. It's the finder's fee, the steering work to Mr. Hughes. That's why he's getting this money. So again, as far as the elements of the anti-kickback statute are concerned, we respectfully submit that as a result of the deposition testimony of both parties in this case, that there are admissions there that end up allowing this court to grant summary disposition under the anti-kickback statute. What I'd like to do, if I can, is address some of the arguments that have been made by the parties' opposition to this motion, and in turn, the cross motion filed by Mr. Mills, Your Honor. And with respect to that, they've raised a number of issues. We tried to address those in our brief, and I know how much time the court spends reviewing that, so I'm just going to try and hit some of those points, and there are some things that we want to make sure that we underscore for the court. With respect to the argument that is being made that Atlas is not a proper party because Atlas does not have a certificate of authority to do business in Michigan, that is a non-issue. Again, we outlined the statute itself. You're not doing business in Michigan by maintaining a lawsuit. So we would be involved in a fact question that this court, I don't believe, could resolve on whether or not underlying this, Atlas was or was not doing business in Michigan, so that we don't have to address that issue. We cited the statute, which allows a party to go ahead and get a certificate of authority to cure that and to maintain their ability to bring a cause of action. Yesterday, Atlas was able to get a certificate of authority to do business in Michigan. We can display that on the screen if the court wants. I just received it late this morning. I sent it over to counsel, so they've at least had an opportunity to receive that and look at it. So that really is not an issue at this point. There is that curing of the, if it had to be cured, the certificate of authority to do business in Michigan for Atlas. Another argument that has been raised is what they refer to as they meaning the defense, the real party and interest issue. And this will blend into, I believe, our discovery issue. And I asked the court's indulgence for us to be able to brief this to understand why we were taking the position that it's not necessary to trace the monies. That seems to be the argument that the defense is making, primarily Mr. Mills, that the real party and interest had to actually be the payor. And we've outlined through the court that the anti-kickback statute, there isn't case law to give us the guidance on it. So we're analyzing that for the court. We believe that it's akin to the aiding and abetting breach of fiduciary duty claims. And we cited the Hayes-Albion case for the court, and Hayes-Albion recognized that under that cause of action, a party can recover what Hayes-Albion calls unjust enrichment damages. We're not saying, and I think there was a blurring here based on the Mills brief, that there's a separate independent action under the anti-kickback statute for unjust enrichment. Not what we're saying. We're saying that under that statute, there are damages, and a element of the damages is the ill-gotten gain. You don't have to be the payor, it's the ill-gotten gain. The anti-kickback statute talks about who really can bring it, and it is an employer or a principal. So we know that Atlas was a principal by way of the agreement between the parties, and there's no dispute that DART was the employer for the officer period here. There may be a dispute about whether Mr. Mills is or is not an officer, but not that he was an employee. So both of the plaintiffs fit squarely underneath the anti-kickback statute provision, and they do not need to show, we respectfully submit, that they themselves are payors here. Because they had that relationship, principal or employer, if there was this kick, it's an ill-gotten gain for Mills, and we have Hughes violating Section 1 of the anti-kickback statute for attempting to influence. And that's why, without being the payor, the DART party here is the proper party, and Atlas is a proper party because they are the party to this relationship in the non-officer period. As far as summary disposition is concerned, the cross motion, again, that's not appropriate even if you were to accept the argument about tracing the money. Again, we have provided the court in our reply brief documentation showing that DART did make payment of $500,000. And this is a document that actually came from the Hughes defendants, the 1099 showing that they received $500,000. This is on one of the transactions referred to as Walton on the Park. And again, the testimony has been that Mr. Hughes provided half of that, $250,000, to Mr. Mill. So there was payment. We have to do that. Additionally, we have DART the named plaintiff here as a party to many of these transactions, and we provided the court with the documents and the list of those transactions. So there would still be a considerable portion of this case where we would, even under the arguments being made, be the proper party in interest and not a basis for summary disposition. Again, we're not asking the court to decide on damages at this point. That's not before the court. This is a liability issue and not a damages issue. So again, we respectfully submit that the real party in interest argument raised here has been misplaced. And, you know, with respect to the open discovery issue, we tried to explain why we submit that the damages here are not, you know, what the Mills party is arguing for, but we can understand that there are some open questions. And, you know, in light of the court's comments at the last hearing, what we would suggest is that we're going to be ordering discovery, then what we provide the information on who paid, so that they can see who paid on these transactions, and then the relationship between the named plaintiffs here and the payor, so that we can provide that information. We'd like to do that under protective order. These are privately held companies, they're not publicly traded, and that should be limited to being disclosed for purpose of this lawsuit only, not outside the lawsuit. So that's our suggestion with respect to that. We provided the court also in our response with the additional information that all of these parties are related parties. And again, you know, the issue with real party and interest, real issue, and by the court with the citation to the authority that was cited in part by the Mills parties, is to protect the defendants from additional claims. And as we indicated in court, we can provide an extinguishment of those claims. These are all related parties. Within 30 days, we can provide an assignment that would extinguish those claims and only bring them through these parties. The alternative would be to file a separate lawsuit, name all these additional parties. What we've attempted to do is to simplify to the extent we can on this, rather than having all of these parties and making it a more complex case. We believe this all can properly be brought by these two named parties. All these other entities are related entities, and they really, the purpose of the motion actually before the court, which is the anti-kickback statute. The cross motion only deals with the anti-kickback statute. They are the proper parties. They fit, employer and principal. And as a result of that, we're asking the court to grant the plaintiff's motion for partial summary disposition on liability on count 8, to deny the Mills cross motion for summary disposition of count 8. And with respect to the open discovery, if the court is going to permit it to do something along the lines of what we outlined here, I'd be happy to try to respond to any questions the court may have.
I don't have any just yet.
Thank you, Your Honor.
Mr. Falcone, on behalf of the Mills defendants.
All right, Your Honor, Joseph Falcone. Yeah, I don't know how to mute and unmute quickly, so I apologize. Your Honor, with respect to the original motion that was filed by the plaintiffs for a partial summary judgment, when I read everything, it looks to me like there's a large question of fact speaking regarding Mr. Mills. There was no evidence in there about an agreement or even an understanding about what was supposed to happen with these monies. In addition, the plaintiffs themselves aren't even seeking damages for what they call transactional damages, or damages that were caused by something Mr. Mills did. They seem to go, when they argue about these damages, they're making the assumption that if Mr. Mills received a fee or referral fee, that the plaintiffs are automatically entitled to it, even if they did not suffer any damages or weren't hurt in any way. They say, oh, it's inequitable that Mr. Mills keeps the money, so there's unjust enrichment. But there's two parts of unjust enrichment. There's the fact that Mr. Mills may have been unjustly enriched, but on the other hand, it has to be inequitable, or there has to be some harm done to the person who's claiming unjust enrichment. It's everybody who finds $1 on the street is unjustly enriched, but unless that dollar belongs to you, you're not hurt. And this is what I have a problem with their whole action about damages. They just make the assumption that, well, if Mills got fees, he's supposed to, we should be entitled to them automatically. Anyway, there's certainly a question of fact as to their motion. As to our motion about not the real party in interest, the plaintiffs do make a list of the deals that they were in, or these leases that they signed, and basically they admit that they had they weren't parties to the other suit, to the other deals, and I've never really heard of somebody coming in and saying, well, even though I don't have a right to sue you, I promise, or it's unlikely that the people who do have a right to sue you won't sue you. Don't worry about it. The suit's supposed to be brought in the name of the real party in interest. I mean, that's just what the rule says. Pretty simple, one of our simplest rules. So I just don't think that, I think that if they're admitting that they're not a party to these other transactions, then they shouldn't be allowed to bring the suit. With respect to the tracing, or my motion for more information, we have to find out who was really hurt by this. For example, our position is that Mr. Mills did not receive referral fees or commissions or monies from these lease agreements. So I really want to track down who paid the commissions on the leases, and how they were going to Mr. Hughes, and then if Mr. Hughes actually gave any money. But a lot of times, I just think that in order for the plaintiffs to say that they were damaged, they have to show that their pocketbook was ultimately decreased. They weren't reimbursed. They weren't just acting as an agent to send money to somebody, that they actually got hurt. And so I think that we should get discovery on that. And you mentioned before that you weren't going to make it that expansive, but I'll be happy if I can just see where the money comes from. That's it.
All right, thank you.
Okay.
Ms. Gross for the Hughes defendants.
Thank you, Your Honor. And thank you for, I know you did take the time to read my lengthy motion, and I apologize for the late judge's copy. We just realized that it was not sent, and so we overnighted it, but I apologize for the lateness and absolutely understand that the court rules require a judge's copy. Just as a couple of preliminary issues to the substantive issues of the motion for summary disposition, as we argued in our brief, this motion is premature. Discovery has not completed. on issues that are relevant to show that there's a genuine issue of material fact with regard to count 8. And the discovery disputes between the Mills defendants and the plaintiffs are different than those alleged by the Hughes defendants. We haven't filed a motion to compel, but there is an outstanding dispute that we are working to resolve related to communications that plaintiffs maintain with regard to these matters. We believe that it will show that the plaintiffs were aware of the payments being made to Mr. Mills, or at least gave him the authority to act on their behalf as an agent with regard to seeking those payments. Further, we're seeking to depose the corporate representative for both plaintiffs. My client has testified in his affidavit that there were other individuals who were involved in the approval process granting the work that plaintiffs are saying my client induced by making the payments to Mr. Mills. If that's true, and we have provided affidavit support for that, that would indicate that that would cut against the inducement of MCL 750.125. So those discovery issues make this motion premature, and we should be allowed to complete that discovery before having to address this issue. A second preliminary issue that I just want to touch on, it's briefed more fully in my response, is the issue of whether or not it's appropriate to find a civil action under this penal statute. I know this issue was discussed before when we brought a motion for summary disposition, saying that there was failure to state a claim essentially under count 8. Your Honor dismissed that, but that is not the same thing, obviously, procedurally, as finding that there's a civil cause of action under the penal statute. That's something that Your Honor has not found as a matter of law, and we would encourage you not to find a civil action available in this case. We have had the opportunity, as set more fully in the brief, to comprehensively search the case law. And while there's nothing in the statute to preclude application to private employees, the criminal cases that were available show that it's been exclusively applied to public employees for bribery type offenses. So while that's not specifically excluded, it does raise a question about the intent of the legislature in creating that penal statute. With that in mind, I've quoted some cases in our brief indicating that the legislature is the best body suited in a case like this to create a new cause of action. And if they haven't done so, that's indication that cause of action under the penal statute may be inappropriate. So I just wanted to mention that quickly. With regard to the substantive issues, I just wanted to respond briefly. We briefed this more fully in my response, but I wanted to touch on a few issues that plaintiffs raised in their argument. Plaintiffs are focusing on the fact that Hughes acknowledged that the money was paid to Mills. He absolutely does, but that is not enough by itself to violate the statute. So even if we assume that there's a civil action available under the statute, and you read the language of the statute, it has to be a payment with the intent to induce certain conduct. So the fact that money was paid is not sufficient to show the requisite intent or what conduct was intended to be induced. So the payments alone are not sufficient, and there would still be a genuine issue of material fact there. With regard to the quote that plaintiffs referenced from my client's deposition, it's really the only piece of evidence that they put forward as evidence of my client's intent with regard to the payments. And their brief, as I mentioned in my response, takes it out of context. They don't include the full quote, but when you look at the full quote with regard to what my client meant when he said that questioning Mills's authority would be the equivalent of business suicide, plaintiffs are trying to say that that means he said not making the payments would be an equivalent of business suicide. That's not what he said at all. It's very clear from the full quote, which is reproduced in full in my brief, that the business suicide comment was related to questioning the integrity of the agents with whom he worked for various clients. So that is the evidence that plaintiff has to show my client's intent. It's the only evidence that they've cited to, and it doesn't show what they are arguing it shows. And then finally, the statute requires payments or promises made with the intent to induce conduct. Here, my client paid finder's fees or to a person after the fact. There was no inducement of conduct. There was no promise to pay. And if you don't pay this, you're not going to get this work. There was no evidence on the record to suggest that that was the arrangement, that there was a scheme that plaintiffs are alleging. And without those types of showings of intent or the evidence to support that intent, even if there's a civil action under the statute, it hasn't been met. So for those reasons, and I again refer Your Honor to the rest of my brief where it's been laid out more fully, I would ask Your Honor to deny plaintiff's motion for partial summary disposition in this case. Thank you.
All right, thank you. And Mr. Mandel, back to you.
Thank you very much, Your Honor. If I can respond first to what we just heard on behalf of the Hughes defendants, it is not correct that the only evidence that plaintiffs are relying upon with respect to Hughes is this business suicide, which really, we're not talking about deposition. That was something that was in an email. We have provided the court with the citation to the deposition testimony. We're not taking this out of context. Counsel didn't even argue about that. What we're talking about is what he testified to under oath. And that's set forth on pages 7 and 8 of our brief. And if I can just read a portion of that to the court, so at least there's a record here of what the actual evidence is that we're relying upon for purpose of this motion with respect to Mr. Hughes. And this, again, it's found on page 7 of our brief. It's pages 51 and 52 of Mr. Hughes' deposition. You already indicated that you have indeed made payments to Mr. Mills or Mills Real Estate Consulting on DART properties that you handle with him. Can you explain why you made payments to Mr. Mills? Answer, as a finder fee or for him given me the opportunity. And when you say given me the opportunity, that's giving you the opportunity for this business. Is that correct? Is that what you mean by that? Answer, given me the opportunity to potentially work on business. Question, and when you say work on business, this is DART related business that we're talking about, correct? Answer, yes. Again, this is his deposition testimony. We're not talking here about what Ms. Gross just outlined with respect to business suicide. He's doing this to get business. And then we go on, and then on page 8 of our brief. And it picks up on page 8, and this is from the testimony of Mr. Hughes, pages 71 and 72. Would it be fair to say you felt pressure to make the payment to Mr. Mills? Answer, I certainly felt the obligation. Question, did you have any concern that if you did not make that payment, it might jeopardize your future work for DART that you were handling through Mr. Mills? Answer, I would certainly say that it would. You know, as part of the relationship in general, that's what the payments were for. That's what the finder fees are for. Again, that's his testimony. And to suggest that we have no evidence of an intent to influence ignores the record here. And to try and contradict that and pretend it didn't happen by saying it doesn't exist or by having Mr. Hughes sign an affidavit is flat out a violation of Atkinson. It cannot be done. And that's why this is properly before the court. We submit for summary disposition. With respect to the other arguments Hughes has made, we'll rely on the brief. I know the court is very familiar with those issues. The court commented in considerable detail about a private cause of action. Unless the court has questions on that, I won't go into that further. With respect to the Mills argument about this saying that someone who finds $1 on the street is unjustly enriched, I beg to differ. What is unjust about finding $1 on the street? That's not what we're talking about here. We have parties, and Ms. Gross is suggesting there's open discovery. There's not. We have an admission by the two parties who were involved in this that they did not disclose the DART. That's under oath. They didn't make the disclosure to DART. And what we have here is Hayes Albion recognizing that this is an element of damages. And Hayes Albion recognized in that case you had a really former employee by the time the lawsuit was filed, who was basically competing against his former employer and violating a trade secret agreement that particular employee had. And the Hayes-Elgin court recognized that there were damages there, because what was going on is this employee was funneling business to these other co-defendants, funneling business, and the work was really good. There was no quarrel about the work, i.e. transactional damages we're talking about here, but there was an overpayment here. And it turns out that the plaintiff could have received the same work for substantially less. That opportunity was not presented. That's what we have here, the ill-gotten gain. Had Mills and Hughes come to DART and said, look, here's what we're going to do. I got $500,000 for this Walton on the Park transaction. I want to reward Mr. Mills and pay $250,000. DART should have been told that and said, wait a minute, if you think you're overpaid commission, that should come to us, not to Mr. Mills. We're paying him a salary for that. So again, we respectfully admit that there are not these fact questions that counsel try to highlight, and ask that the court grant our motion for summary disposition on liability on count 8, deny the Mills cross motion for summary disposition, and then if the court's going to order discovery, to do something along the lines that we suggested. Thank you, Your Honor.
Thank you. Mr. Falcone, I'll give you rebuttal too, since you have your own cross motion.
Thank you, Your Honor. It seems to me that we still have the problem about the damages that the plaintiffs are claiming that if somebody receives a payment, my client receives a payment, that somehow automatically that they're entitled to it, and I just don't see any support for that. I did forget to mention last time that we do have the situation where my client had a contract that said he was not an agent or was not an employee until September of 2016. And the government's, not the government, Mr. Mandel's claiming that he was an agent. Somehow it was a real estate agent when DART had hired Mr. Hughes and Newmark, and specifically said my client wasn't a agent. And it just seems to me that just goes totally against the contract they signed. Thank you, Your Honor.
Okay. Okay. So the motion for partial summary disposition that the plaintiffs brought pertained only to count 8, the anti-kickback claim. So unless I indicate otherwise, and I will farther down when we get to some of these other issues, everything I say initially at least is intended to apply to count 8 only. And again, I will indicate otherwise at some point, because it seems like the Mills defendants cross motion raised issues beyond count 8, although I have to confess at times it was hard to tell. But anyway, I'm going to try and take these issues in like the logical order that the issues fall in, rather than taking them by party or by motion. And in that regard, I will start with the Hughes defendants' argument that there's no civil cause of action under MCL 750.125. Of course, I've already found that there is, because I denied the defendant's C8 motion, which was based on the argument that count 8 failed to state a claim. I ruled that it did state a legally cognizable claim, and there's no further ruling that's required. I mean, I don't have to make like a declaratory judgment ruling that it's a claim. I've already ruled that it is a legal claim under the statute. So I won't address the other Hughes defendants' arguments about that now or in the future because I've already ruled on that issue and it's done. As to the Mills defendants, the elements of this claim in count 8 are, I've boiled it down to 3, and that is that the defendant was an agent or employee of plaintiff, that the defendant requested or accepted a commission, gift, or gratuity, and that when the defendant requested or accepted the commission, gift, or gratuity, it was according to an agreement or understanding between defendant and any other person that the defendant shall act in a particular manner in relation to the plaintiff's business. The Mills defendants first say that with respect to the first element, because again, I'm taking these in logical order, Mr. Mills was not an agent of the plaintiffs from 2012 to September 2016. And the plaintiff responds with some case law that talks about whether an agency relationship exists. In the cases that are cited by the plaintiff, a person is making a claim against both a principal and an agent and claiming that both are liable. In those cases, there was no written agreement that expressly defined this purported principal-agent relationship. This case is entirely different. Mr. Mills, through Mills Real Estate Consulting, acted on behalf of the plaintiffs under a consulting agreement that provided as follows. Quote, Mills shall perform the consulting services hereunder as an independent contractor, and nothing contained in this agreement or otherwise shall be deemed to create any other relationship, including employment, partnership, agency, or joint venture between Mills and client, end quote. So in this case, unlike the cases cited by the plaintiff, there is a written agreement that expressly provides for the relationship between Mills and the plaintiffs. Also, unlike the cases cited by the plaintiffs, this is not a case where we are attempting to define the relationship between two defendants. This is plaintiff, a party to the consulting agreement, suing Mills, another party to the consulting agreement, claiming that Mills is an agent of plaintiff when the agreement says that he's not. That's why the plaintiff's argument that we can't allow people to characterize themselves in a way to avoid liability makes no sense, because Mills didn't unilaterally do this. Plaintiffs agreed to it. They both agreed that he was not, or his LLC was not acting as an agent of plaintiffs. What makes more sense to me is that someone can't say, we agree that you're not my agent, and then turn around and sue them under a theory that requires an agency relationship. And likewise, I acknowledge Mills may have testified that he was acting as an agent of plaintiffs, particularly during the one transaction that was pointed out. His characterization is not dispositive in light of this written agreement that expressly disclaims, by all sides' agreement, any agency relationship. So I agree with the Mills defendants that the claim in count 8 cannot be based on the time period of 2012 to September 2016, when Mills was representing plaintiff under the consulting agreement. I believe that the consulting agreements are dispositive on the agency issue. And I say consulting agreements, I've shortened it down as I've been describing them, but there was one with Atlas and one with DART. So I think they're dispositive. They both disclaim any agency relationship, and they're dispositive on this agency issue as to count 8 between that specific pre-officer time period, as we call it. And that's why I won't address the additional arguments about Mr. Mills' role and whether it was as a real estate salesperson or a real estate broker, again, because I think that the agreements are dispositive of this issue. So now I'm going on to consider only the time that Mills was an officer. Plaintiff claims that there's no genuine issue of material fact under the what we call the anti-kickback claim as to both Mills and Hughes, because both of them, according to the plaintiff, admit to a scheme that satisfies all the elements of the anti-kickback statute. There's no dispute, for purposes of this motion at least, and for the officer time period, that the first and second elements are satisfied based on testimony and admissions from both Mills and Hughes. That is, that payments were made. And no one disputes that during the officer period, Mills was an agent or employee. So there's no issue there. It's the third element that is called into question here. Again, as to Mills, the third element is that when he requested or accepted the commission, gift, or gratuity, it was according to an agreement or understanding between Mills and any other person that Mills shall act in a particular manner in relation to plaintiff's business. As to Mills, the plaintiff says in the briefing that Hughes testified that he made payments to Mills with the understanding between them that Mills would continue to funnel lucrative DART-related real estate work to Hughes, and that he intended to influence Mills to act in a particular way with respect to DART's real estate business, specifically by referring more business to Hughes in the future. I'm not saying plaintiff's misrepresenting that. I think plaintiff is putting a conclusion on it that if you just literally read the testimony isn't exactly there. He never said, and it's most of it's at page 51, page 52, like Mr. Mandel quoted. He never said they had an agreement or understanding between them with respect to DART's real estate business. He said he made the payments as a finder fee to Mills for allowing Hughes to work on DART business, and that he felt he could not say no or bargain with Mills without fear of losing future business. That testimony only reveals what was in Hughes's head and what Hughes's motivation was in making the payments. It doesn't reveal an agreement or understanding between them. It reveals a unilateral understanding or agreement of only Mr. Hughes. But more importantly, and I say more importantly because it could be argued that there is circumstantial evidence based on that testimony of an agreement or understanding, and I acknowledge that. But more importantly to me, it shows that Hughes made the payments to protect Hughes for future business interess. But it fails to show that the payments were made so that Mills would, and this is the language required in the statute, so that Mills would act in a particular manner in relation to the plaintiff's business. I don't think the statute covers paying a finder's fee to ensure more work in the future for the person making the payment, because the statute expressly requires an agreement that the agent or employee shall act in a particular manner in relation to the principal's business. Just paying a finder's fee to promote your own business in the future would take innocent conduct and turn it into illegal conduct under the statute. Now, I understand that plaintiffs are saying, well, we should have had that money, but they're saying that as a measure of damages. And that, to me, does not mean that there's an agreement or understanding that by receiving a finder's fee, Mills would act in any particular way in relation to the plaintiff's business. That's with regard to Mills, who never testified about his intent or understanding with Hughes. I know he has an affidavit denying it, but that is arguably contradictory and not allowed. The element pertaining to Hughes is that he must have the intent to influence the action of Mills in relation to plaintiff's business. And again, for almost the same reason, the testimony doesn't establish that. If giving Hughes more work in the future or DART made some change in relation to how DART conducted business, then that would be a different story. But very important to this issue is DART isn't claiming that the deals were somehow unfair to it. They aren't claiming that they were paid too much on these deals or that they got too little. They're claiming that their damages should equal the amount of payments, but that's just a measure of damages. That doesn't go to constitute an agreement that Mills would act in relation to plaintiff's business in a particular way. And DART certainly isn't claiming that somehow they weren't wanting the services that Hughes provided through Mills, or that Mills obtained services from Hughes that were deficient or harmful or, again, not wanted. None of that is being claimed. So again, the only business that Hughes acted on was Hughes's business. He wanted to ensure he got this lucrative business in the future. And there's no doubt from the testimony that, the payments were made. There is no doubt from the testimony that it was considered a finder's fee. I just don't think that requirement in the statute is established from that testimony taken on face value as it was made. And again, if you treated what Mr. Hughes said, that a finder's fee could qualify under the statute, then you would be taking innocent conduct and turning it into illegal conduct. The only business that Mills acted on was Hughes's business. So I think the plaintiff's motion for summary disposition on count 8 has to be denied. And although the Mills defendants seem to have argued today that there's an issue of fact, they argued in their briefing that their motion for summary disposition on count 8 must be granted. And plaintiff in response didn't argue that there's any further discovery that's needed to show that there is some kind of a factual dispute. So I think that the Mills defendant's motion for summary disposition on count 8 must be granted. The Hughes defendants just have flat out all along claimed that there's just an issue of fact on count 8. But the issue that I've just discussed regarding the Mills defendants applies equally to the Hughes defendants. And whenever it appears to the court that the opposing party rather than the moving party is entitled to judgment, the court must render judgment in favor of the opposing party. So I think, like the Mills defendants, the Hughes defendants should be granted summary disposition in their favor on count 8 only, which takes us to the damages issue, which the plaintiffs have argued that the Mills defendants rather have argued that the plaintiffs can't recover commissions because the plaintiffs weren't authorized to receive commissions by law in the first place. I'm not sure if that's just related to the anti-kickback argument or if it relates in general to all of the claims. But if it relates to the other claims, I very strongly disagree with that. To the extent that they were, let's just say they were commissions at the time they were paid, they're a measure of damages now as to these other claims. And that's very different than saying we're restoring commissions to the plaintiff. What we're saying is, and this is the plaintiff's theory, is that the commissions that were paid are their measure of damages. So they have breach of fiduciary duty claims that represent the bulk of their claim damages of in excess of $6 million. And I don't think that the statute that says that they would not have been authorized to receive a commission on these transactions precludes them using the commissions that were paid by them to Hughes as a measure of damages for those other claims. So to the extent that that argument is based on the other claims, I have to reject that argument. There's another argument that the Mills defendants have made with respect to, and it relates to the damages, and that is that they've argued that DART's not the real party in interest unless it paid commissions or was a contracting party to the transaction. Now they seem to have shifted that a little bit, and they seem to be saying, no, you have to be the one that paid the commissions. So out of 45 transactions that are on the Exhibit C to the complaint, DART Michigan was a party to about 20 of them. I think maybe 21 is the more accurate count. The other 26 transactions are with other entities that are listed in the Mills defendant's brief. And the plaintiffs say that, well, there's 20 that DART was a party. There's there's 21, excuse me. There's another one where DART Michigan was the entity that paid the commission, and that's Walton on the Park. But it seems to me that the Mills defendants are now saying that we have to have discovery, and it has to be shown for this real party and interest argument who paid the commissions. The real party and interest requirement is really a standing doctrine. It's meant to ensure sincere and vigorous advocacy. The real party and interest can be the party vested with the right of action. It doesn't have to be the party with the beneficial interest. I don't think that the Mills defendants are required to take the plaintiff's word for it when they allege in the complaint that DART Michigan is the parent company of the other entities. And if DART Michigan is seeking from defendants some $6 million plus in equal to the amount of commissions it paid to Hughes, then Mills should be able to test whether DART Michigan paid the commissions, or at least whether DART Michigan's relationship to the other entities that did pay is such that it would ensure sincere and vigorous advocacy. I'm far from ruling that DART Michigan is not the real party in interest. Even if they didn't pay, it potentially could be cured. But I do think that some of this disputed discovery should be provided. So as to all the Exhibit C transactions where DART Michigan was not the direct payer of the commission, plaintiffs should produce or shall produce all corporate formation, organization, or governance documents that demonstrate the entity's relationship to DART Michigan or Atlas. And plaintiffs shall produce all canceled checks, wire transfers, settlement statements, bank statements, or credit card statements that show the entity that made the commission payment for all the Exhibit C transactions, except for Walton on the Park, which is already known through discovery. That discovery should give the Mills defendants the information sought as they've described it in order to show, as they put it, the real party in interest and who made the commission payments. Their remaining discovery requests are either irrelevant or overly broad. Most are redundant as far as revealing the information that would be relevant and contained in the discovery already that I've just ordered. And then that just takes us to the motion in limine. I think no longer is relevant due to the disposition of count 8. And because that's the only thing that that expert testimony bar pertained to. And expert testimony, the court has not made any ruling and is not asked to make any ruling on whether experts have been named in a timely fashion or whether experts could still be named or what the content of expert testimony could be. So that's all left wide open. And then finally, with regard to Atlas, the Mills defendants say that Atlas has to be dismissed because it hadn't met the requirements of MCL 450.5007. I think there's a lot of reasons why that is not true. However, counsel has informed the court that Atlas has cured the situation. I don't really agree with the argument that they have to be, that the statute does not mean that they have to be currently transacting business, but rather they get into whether they are transacting or not. Atlas, again, has cured the situation with meeting the requirements of the statute. So the dismissal of Atlas USA Holdings is denied. And for those reasons, I am denying the plaintiff's motion for partial summary disposition and granting the Mills defendant's motion for partial summary disposition only with respect to count 8, granting judgment in favor of the Hughes defendants only with respect to count 8, and granting the motion to compel in part, as I've already indicated, and the motion in limine isn't needed.
Your Honor, may I ask one question?
Yes.
Thank you. I understand the court's ruling in the discovery. I specifically asked if we could have a protective order, and I'm wondering if that is something we could include.
Yeah, I'm sorry, I meant to say that. That would, of course, be under a protective order. These are not publicly traded companies, so.
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
Thank you very much.
Thank you.
Thank you, Your Honor.
That will conclude our hearing.